Okay, good evening. Great to see everybody here. So let's start by reading the passage, which is the first page of the Makorot. The law of divorce is introduced in the Torah apparently tangentially. It's the background information for the prohibition against remarrying your divorcee if she has married someone else in between. Right? So as opposed to setting out the law of divorce as a direct goal, it says if a man marries a woman and they get divorced, and then she marries somebody else, then he cannot, and the second man divorces her, then he cannot marry her again. But along the way, it gives us all this information about the law of divorce twice. So Devarim 24:1-4 says, if a man takes a woman as wife and husbands her, and it happens that if she does not find favor in his eyes, he found in her an ervat davar. The word ki is highly ambiguous. And he writes her a document of cutting off, a sefer kritut. He gives it into her hand and sends her away from his house, and she exits his house, and she goes and becomes wife to another man, but the later man hates her, for better translation of saneh. And he writes her a document of cutting off, he gives it into her hand and sends her away from his house. Or, if the later man dies, who took for himself as wife, it is not possible for her first husband who sent her away to return to take her to become wife to him. Okay. The thing that matters for us tonight, first, in this pasuk, is that so far as we can tell from this verse, divorce is a private transaction between a man and a woman. Right? If we have a man and a woman, they are married. The marriage, we'll talk about whose will and how, perhaps later in the shir. But somehow the marriage is intended to be to end. So the man writes a document and gives it to the woman. This bears no relationship at all to the way divorce is carried out in practice. A halachic divorce never takes place privately. I'm not aware of any case that has happened in which a man has actually sat down and written a divorce and handed it to a woman. It always takes place through the mediation of a beit din, of a court. So the first question we have to ask is, why did this happen? Why is it that the law of divorce necessarily takes place in a beit din, and so far as we can tell, in all but the most unusual cases, has always taken place through the mediation of a beit din for many, many, many years? So last week I set out the thesis that what the rabbis derived from the apparently unique structure of Jewish divorce in the ancient Near East, namely that the divorce process ends with the woman holding a receipt, is that the purpose of the Jewish divorce ritual is to ensure that the woman ends up with the capacity to unambiguously demonstrate that she has been divorced. And in order to accomplish that, what they did was they ritualized and centralized the process so that you didn't have to worry about documents that might or might not be valid, or about an incapacity to demonstrate that had been possibly given. So I want to set that out as the primary reason for the transition, apparent transition from the law as it appears in Torah, which is that divorce can take place without the mediation of a beit din, to the law as it plays out in practice, which is that everything happens through the offices of a beit din. What I want to do tonight is to give you a basic tour of the way in which the divorce process actually happens under the current halachic system. So I should say as basic premises for this that I have two basic experiences that generate my information on this. One is that for the past 10 years I have served on the Beit Din of Boston, and the other is that for several years before that I served on the sort of ad hoc Beit Din of Elizabeth, New Jersey, or the traveling Beit Din of Elizabeth, New Jersey, which is formally under Rabbi Tights of Elizabeth, but in practice the traveling Beit Din was under Rabbi Chaim Jachter. And I will try, so I have two different experiences. Both, the two that I did do not handle things exactly the same way, and neither of them necessarily are universal standards. I will try as I go through this largely to give you the experience the way it happens in Boston now, but to make notes where that might diverge from either what is standard or what might be. So you can get a sense of that, and I'll try and both convey to you what happens and to give you a sense of what the choices are that generate what happens. Okay, so if you look at the verse again, so you'll see that the first thing that it tells you in the divorce process is it gives you the grounds for divorce. And actually, if you look at the verse, it seems to give you three different grounds for divorce, all grounds for the man, not for the woman. Right? One is if she does not find favor in his eyes. The second is he found in her an ervat davar. And the third, which relates only to the second divorce, is but the later man hates her. So how does this play out halachically? Do we really require grounds for divorce or not? So this, is an issue in every legal system as to whether you have what is standard in most states right now in the United States, which is what we call no-fault divorce, which is that you don't actually need grounds for divorce. You have what was standard until the 70s in most states, which is some requirement of fault for divorce. I think usually the standard grounds for divorce were adultery, abandonment, or extreme mental cruelty. And at some point that process stopped because it became ridiculous. Because when divorce became a common enough feature, people started manufacturing the grounds for divorce. I remember the funniest one of these were the adultery hotels that used to exist in New York State, which provided the service of enabling you to be filmed apparently committing adultery, so that you could go to court and be divorced. So, right, the question, right? Louisiana has now put back covenantal marriage, which actually, right, you can actually choose when you get married in Louisiana whether to enter into normal marriage, which is no fault divorce, or covenantal marriage, where you can't evade the system, you can't divorce unless there are a certain set of grounds. So it's worth investigating what the halakha was on this issue. Do we have no fault divorce, or do we require some kind of grounds? So if you look at source number 2, the second page, right? So Gemara and Gittin, Daf Sadi Amar Aleph. I'm sorry, I didn't number the sources. So you'll see that there's a three-way machloket: Beit Shammai, Beit Hillel, and Rabbi Akiva. Beit Shammai say that in order for a man to divorce his wife, he needs to find in her a devar erva, which means that there's some grounds of infidelity necessary, and other than that, Beit Shammai do not seem to permit divorce. You have a second position of Beit Hillel, which says afilu hikdicha tafshilo, even if she burns his dish, which might be literal or might be some kind of double entendre that has been lost in the mist of history. I'm really not sure. But even that is not the most lenient position. Rabbi Akiva comes along and says even Beit Hillel seem to think you have to find grounds for fault, as opposed to simply Rabbi Akiva's position, which is absolute no fault divorce, that you can just find somebody who attracts you more. Okay, then we ask the question we always have to ask halakhically. So those are the grounds which permit divorce. What happens if you divorce even when there are not adequate grounds? A question which applies only for Beit Shammai and Beit Hillel. And so Rava tells Rav Papa that these are only laws l'chatchila, but b'diavad, after the fact, a divorce that was given even without adequate grounds is valid. And then Rabbi Lazar comes along and puts a moral perspective on it, and he says, although it works, but anybody who divorces his first wife causes the altar to weep for you. And he quotes a verse which talks about the altar weeping for because of men who betray the wives of their youth. Okay, those are the positions you have in the Gemara. So we paskin halachically with a very, very interesting hodgepodge of these positions. The Shulchan Aruch, the next source, says that a man must, according to Rav Yosef Karo, a man must not divorce his wife unless he found an ervat davar regarding her. And I think that is a clear ruling like Beit Shammai, but only, which is odd, but to figure that out, but only in the case of the first wife. That's how he resolves the issue. That the machloket Beit Shammai is only about subsequent wives. But then the Ramah comes along and says, nonetheless, we say that anybody who divorces his first wife, the altar weeps. But then the Ramah puts in a really important line. He says, this was only true in their days, when you could divorce women against their will. So when you were dealing with a divorce that was non-contestable, so then you had to have grounds. But now, where divorce is mutually agreed, the Ramah says there is no prohibition against divorce regardless of fault. Right, so that is the practical outcome the Ramah gives you, is that there is no need for fault in divorce so long as both parties agree. So what does that mean in practice? Actually, so we asked the side question: why do we only have grounds for men and not for women? So you can make assumptions of patriarchy if you want, or you can simply argue that all the grounds for divorce are either grounds where a divorce is all the verses are designed either to create situations where divorce is obligatory, or situations where divorce is permitted even though you might have thought it was not. And maybe everyone understood that women have neither obligations or prohibitions to divorce, that women's divorce, right to initiate divorce was always volitional, and so there's no need for verses at all. So you can take whichever of those approaches you choose. In practice, because the outcome, according to the Ramah, which I think is Muslim according to everybody, I don't have enough experience with Sephardi courts, but I'm not aware of any real practical difference in this regard. In practice, in the United States, where the situation that leaves out is what if one party wants to be divorced and not the other. But in the United States, because there is no coercive jurisdiction, there's no way you could possibly compel people to come to court unless they want to. So we have, in practice, a no-fault divorce system, which means that when somebody calls up and asks about halachic divorce, there is no need to ask about cause. It does happen, but if you look at the application, which we'll talk about more in a moment, so the written application for divorce, which is usually the way the process happens, is you make a phone call, because we don't have a strong enough website yet that you can you can do an email inquiry, you make a phone call. Right now we don't have adequate secretarial help answering the phone, so somebody calls you back. Although it would be nice if we could get back to the point where we actually had someone answering the phone. And the result of the first consultation, usually, unless somebody referred you to one of us directly, is that you get an application. So one of the questions on the application asks for the grounds for divorce, but there's no inquiry about it at all. Interesting question whether we ought to or not. Traditionally, in Europe, it seems like usually the reaction to people filing for divorce was to try to discourage them. But that in practice does not happen in our Beit Din. There are a couple of things that do happen. We will often ask about whether the couple has gone to counseling, and if they say no, we might raise an eyebrow. We don't actually do anything more than raise eyebrows. In my 10 years, I think now in the Beit Din, there were twice when both times at my initiative, which was probably hopelessly naive, we actually stopped for a moment and asked the couple if they really wanted to do this. And both times they said yes. One time I actually talked to them privately for 15 minutes, and they still said yes, and that is the extent of the attempt to discourage the process on our part. We do have to ask about civil divorce, which we'll get to in a moment, about the state of the civil divorce. And Rabbi Pollack, who's the head of the Beit Din, is fond of giving an example, apparently based on certain feelings about his experience in couples, maybe in Lebanon Earth, which is really, really old, that divorce should not be the equivalent of being in a bagel store and taking a number, where the people serving you have no idea who you are. So normally in our Beit Din, we do before the actual handover of the document, we do ask people for a brief description of why the marriage went wrong, so they should feel that there was the ritual has some relationship to their own experience, but it's not in any way a halachic phenomenon. It's entirely a pastoral decision, and if it looks like the result of that will be nuclear war, then we skip it. Okay. Now, so the question we do have to ask is what is the status, or at least that we do ask, and we'll talk about why, is what the status of civil divorce is. Now, the reason for that is it used to be in the United States that the standard practice was that you did not write a get until the civil divorce was complete. Right? There were good halachic grounds for that. The halachic grounds for that were that in the theoretical halachic system, a divorce takes place, a get takes place in the same ways it takes place in a civil system, which means it takes place after all outstanding issues have been resolved, including financial issues and child custody. And the reason you would want that to be true halachically is you don't want the husband or the wife to be able to, or especially the husband, to be able to claim later that I gave the divorce on condition. Had I known that the custody ruling would go against me, or that the assets would be divided in a way I found unsure, I would never have given the divorce, and therefore I attacked the validity of the divorce. Might be that in a time when people were more optimistic about the possibility of people reconsidering, that you also hoped that the civil divorce wasn't final, there was still hope for reconciliation. The tradition of both Beit Midrash being apart, which we understand is coming from Rav Moshe Feinstein, is that in the United States, the risk of especially the husband, but really, in our experience, at least as much the wife, changing their mind, and then refusing to go through with the get as the result of the outcome of the civil divorce process, is so great that we write a get immediately. Really, no matter at what stage the civil divorce process is, and we rely on the various halachic mechanisms that we'll discuss as we go through it to ensure that there cannot be a later claim that the get was conditioned. Okay. Yes.
Is the timidity, if you will, in that sense of worrying about the get not being given, also what drives the desire not to really counsel or otherwise kind of stoke the flames? Was going to just get through it?
Yeah, although I think it's partially timidity and partially realism. That it's not like there might be some good things happening, but we're worried about bad things happening. It's that. So let's talk about where we are in the civil divorce, right? That's the big issue. So when a non-Orthodox couple comes for a civil divorce, and most of the divorces that we as a Beit Din do are not for the Orthodox community, so they almost always come after the civil divorce is complete. We can talk about later why that's not necessarily a good idea and how we might want to change that, but the reality is they almost always come after the civil divorce is complete, and then there's really no issue of counseling. It comes up more often that Orthodox couples do it before the civil divorce is complete, and that is clear of Moshe. The more challenging circumstances is that we not infrequently have Orthodox couples come to us, especially young Orthodox couples who haven't even filed yet. And there if they haven't filed for civil divorce yet, the first thing they do is come for a get. And there you have a temptation to try to engage in counseling, but generally we resist this. And that's more an issue of timidity. That really, if you just take the assumption that, you know what, unless he's a Kohen, they can get remarried if they want. Right? Let's write the get. Let's write the get and see what happens.
Is it mutualism?
Sorry?
Do you require mutualism? If one spouse says I want a divorce, and the other one doesn't.
So you cannot halachically now divorce either party without the other party's will.
Okay.
So there's really no option about that. One of the questions you ask, yes, right then.
I don't want to jump in, but if at some point I could give a Maisa Shahaya at the VOD that addresses Roger's case. You may be.
Okay, we may get there.
To do that. Yeah.
We may get there. Okay. Okay, so really I would say the usual non-Orthodox case is civil divorce is complete. Usually the non-Orthodox couples come to us for divorce because one of them wants to remarry. Right, where the get is less the end of the previous marriage than the entree to the next marriage. It's kind of the equivalent of everybody shouting Mazel Tov when you break the glass at the wedding. Right, it's supposed to make you sad, but really really makes everyone happy, so that's what a get. In the non-Orthodox community, a get is usually a sign of remarriage as opposed to the sign of the end of the marriage. In the Orthodox community, the usual case is somewhere in the process of the civil divorce. Every once in a while, if you get an unusual case, such as somebody going into a dangerous situation who wants to write a conditional get, which has a long history going back to to King David's soldiers writing conditional divorces to their wives, which is still used in the Israeli army. And we've gotten at least one question over the past number of years. I think probably right after 9/11. and somebody wrote a question like that before they could give their wife before taking a long plane flight. But those are really odd. Now I'm describing an American situation. In Israel, they don't have to, they couldn't ask the question about a civil divorce because there is no civil divorce. So in Israel, for good or for ill, and based on popular reports, almost entirely for ill, but I don't have a direct experience. In fact, because they control the civil procedures also, I think there is much more of an effort to send people back to what they call Shalom Beit. But I haven't heard very positive experiences about that, but perhaps the positive experiences don't get publicized. Okay, so now what actually is on the application? So the application, first it requires your names, and that we'll see later is a huge element halachically. What it means to write a name. Secondly, it includes contact info. That's totally practical. It includes the names of the fathers of both the husband and wife. That's the unusual case. The unusual case that comes up there are matrilineal Jews, where you're really supposed to write the mother's name as opposed to the father. And the question then, of course, is what happens if you have a circumstance where you really are not sure whether the father was Jewish or not. So that raises all sorts of interesting conversations. And then, forget the Jewish status of the father, what about the Jewish status of the applicant themselves? So the practice of our Beit Din, I think this is a very important issue. And this was, I think, largely the practice of the Beit Din I was on in New York also, although I don't remember the conversation being anywhere near as explicit, is you have to make a decision as to whether you are the Beit Din of the Orthodox community or whether you are the Beit Din of the Jewish community. If you are the Beit Din of the Jewish community, then you cannot distinguish between those people who are considered Jewish by the entire community and those people who are considered Jewish only by the Orthodox community, because it's not reasonable to expect people to walk in voluntarily to your Beit Din if they know they're going to be interrogated about the validity of their Jewish status. So the practice of the Beit Din is that in the standard case, we write the get without regard to the Jewish status of either party. There is a reason to ask, which we'll talk about later. And
if a Jew were married to someone who's not Jewish,
yes,
it's not really a valid marriage. They don't need a get.
That's right. They don't need a get. I didn't say it right. Obviously, if they needed a get, we would write it. The question is whether we should engage in the investigation as to whether they need a get.
You just always write it.
So our practice is to write the get, because the only way out of it is to say that when non-Orthodox Jews walk into Beit Din, they have to prove their Jewishness. And that would practically mean that they would not walk in. So we don't do that. What it does mean also, however, is that the presence of even an Orthodox get cannot be used as evidence of Jewish status. Because if you know that Orthodox Beit Din will write gittin for people who aren't Jewish, so you have to realize that holding a get is not proof of Jewishness at all, and that's the practice that you have to go for. There are theoretically ways in which you can indicate on the receipt whether you take responsibility for the Jewishness or not. In practice, since you don't see it as a primary responsibility to investigate, so really the fact that someone has a get in this circumstance is not evidence of Jewishness. Okay, but you also have to talk about previous marriages, and that relates to this issue. So on the application, we'll ask you were you previously married or not, and then you have to ask if they were previously married if they received a get or not. So now the challenge there is sometimes you have to ask that question for one of two reasons. Either if the person is going to be the question about previous marriages matters because of the possibility that there are children from the second marriage. And if you find out that they were married the first time, so then you really, first of all, you can't, and even if they weren't, first of all, you can't write a divorce for a second marriage unless you, if they're still married to the first guy. Because they weren't married to the second, right? You can't marry two people, right? You can't marry two men simultaneously. So if the woman was previously married, and she didn't have a get, so then you have to worry about that. You have to worry about that the second time. You also have circumstances where people come in and they have multiple relationships and they're trying to get getting from all of them. Right? Someone's coming in, they're remarrying, but they've been through 2 marriages previously or 3 marriages previously, and the issues of mamzerut get very tangled. There are 2 reasons that you might not want to write a get, even though somebody wants one. The first is if they wish to remarry a Kohen. Right? The second marriage is going to be to a Kohen, so you don't want them to be a divorcee. Right? Kohanim don't have to marry virgins, right? But they can't marry divorcees. So if you know that, or even if somebody's just coming in for a divorce and they haven't chosen to remarry yet, but you don't want to limit their pool of prospects. So you don't so in those circumstances you investigate whether you really need to write a get or not, because you don't want to write an unnecessary get. And then particularly if there's a risk that you will, by recognizing this marriage, create when you have these multiple cases, that you'll create mamzerut by saying she was really married. But if you write a get for the first marriage, then that suggests that when she was married to the second person, she was committing adultery, and the children from the second marriage are mamzerim. So then you will refuse to write a get if you can find a way for the first marriage. Okay, everyone understand that case? Someone's coming in for a third marriage. So so for those reasons, you have to ask about previous marriages, and you have to understand that before you write the get. Yes.
So how would you find a way to make the first marriage not?
Okay, good. So the practice of the Beit Din in New York was that we relied on Rav Moshe Feinstein's responsum that if you could demonstrate that the first marriage had not been conducted under Orthodox auspices, though you write a get if there's no other reason, right? But if there is a reason not to write the get, you can rely on that. Our Beit Din, when I first joined, was much less sanguine about that. I think, and we used to send the cases when those cases came up. At least since I've been a part of it, we used to send those cases to a different Beit Din that would rely on Rav Moshe. So we didn't have to do that. I think that it now being 10 years or so, we've become a little bit more comfortable with relying on Rav Moshe. Sometimes that you really prefer not to rely on that absolutely if you have a choice. So I remember Rav Aaron Soloveitchik, when I was in Shir, used to talk about looking at the one case where he looked at the wedding photos and he saw that all the relatives were 6 feet plus and they were ringing the chuppah. So there couldn't possibly have been any valid, none of the relatives were from, so there could not possibly have been any valid witnesses who saw anything. Right? So instead of just relying on Rav Moshe, he relied on his own vision of the wedding pictures to show that there were no possible valid witnesses, because nobody could have seen anything. There was a case that I was involved in New York, I don't know the outcome of it, where we watched the wedding video and booing the rabbi as he got everything right. Where he was asking, he made sure he owned the ring, and he made sure that he and the cantor were the only witnesses, and we didn't know that he wasn't Shomer Shabbat, so we were booing all the way through because we were trying to validate. In the end, I asked the grooms, when were you married? And he said we were married when we were married when they broke the glass. Which meant that nobody had explained to him that he was married at the moment that he was giving the ring to effect the marriage. So we wrote that up and sent it off to Rabbi Dalia Schwartz to ask if that was sufficient grounds to declare the wedding invalid, but I never heard what happened. Yes?
You were at a wedding where after the young man gave the woman the ring, the woman gave the man a ring, and they also attested the value. Does that make that not?
And they also what?
The woman then was a double ring.
Yeah.
And they also had somebody come up and attest to the value of what the woman was giving the man. Does that make that then not a non-valid?
So good. That double ring ceremony is a complicated. If it is framed as an exchange, as opposed to the man gives the ring to effect kiddushin, then certainly if you had a real interest, you could invalidate it. Usually in contexts that aren't explicitly non-Orthodox, there are much cleverer devices to include the second ring. In some cases, the condition, even if we didn't want necessarily approve of the appearance, are certainly valid. In some cases, you can see arguments both ways. You really have to talk about the specific. You really have to talk about the specific device that was used. Those are not cases you could just say, oh, it was a double ring ceremony. Ceremony is invalid. You really have to know, right? You really have to know how it happens. And it's pretty standard in non-Orthodoxy to give a second ring in the yichud room, right, where it's clear that it's not a reverse kinyan. But there are more complicated. That's a different share. They're more complicated versions. Some of them are really very clever, and certainly the condition itself. Okay. Yeah.
People tend to be receptive to having their marriages invalidated, so they don't have to get divorced.
Good question. Good question. Do people tend? So that I think is that's a very sensitive pastoral thing. And so two things I want to try and convey here are A, that being halachically valid is not enough if you're pastorally insensitive. So you really have to be careful when you're doing that, right? Just that you can't walk over to somebody and say, oh, you know what, he wasn't Jewish, you can just leave. Or, right? Or marriage, you call that marriage? Right? Right? Those are both bad ways to handle the circumstance. The second, perhaps more subtle point is that administration makes a difference also. Returning phone calls promptly, not losing information, all those sorts of things will really matter. So the answer is that I think, again, the default setting is that we write the divorce. If a person insists, right, we might present people the option sometimes, right? Especially, again, if it's a woman who has not yet decided who she's remarrying. So there's the possibility she'll remarry a Kohen. If it's a mamzeret case, right, we're not going to write the get, no matter what the couple wants, because we're not, right, because it hurts somebody else. But if it's a question of whether the woman will be a surah l'kohen, so then that we can really talk to her, right? Look, there's a consequence. On the other hand, there's a real cost. I think that the conversations about annulment, which we're not having tonight, we have to realize that annulment as a technique has real emotional costs on the party that you have to be aware of. So yeah, so we would not do that without consulting with the person and making clear, right, what their wishes are. Thank you.
I thought you started to talk about that part about it's only if they were coming to you for this, to get a get from the second marriage, and you have to know or undo the first marriage, so to speak.
Well, I guess but sometimes again,
but sometimes now you're saying also just if this is
just the first marriage. Why should you make if it's a case? So I would say it this way: if it's the kind of marriage where, so we'll go back. There's a fundamental dispute between Rav Moshe and Rav Henkin. Rav Moshe Feinstein ruled that you could presumptively declare all non-Orthodox marriages invalid, and non-Orthodox marriage is the least of it. Rav Moshe, right? The question is civil marriage. Right? Rav Moshe held that you could simply say if you had a civil marriage you didn't require a get. Rav Yosef Eliyahu Henkin, who was a really great posek in America, much less remembered now, but who really had enormous stature in America in the really the 30s or the 70s. So he took the standard position. There's a question about how far he took it. Did he hold it in cases of mamzeret or not? But his standard position was that civil divorce is required again. So if somebody comes with a genuine civil marriage, they live, and especially if they live together as husband and wife in a Jewish community, which strengthens the case, then you really have to write the get, even if you think you could invalidate the marriage, because you don't want to run the risk that they'll show up in a Beit Din that rules like Rav Henkin. Right? It's not worth it. But sometimes people come in with circumstances where it's really obvious that almost anybody would look at this. And the extreme cases where it's really, really clear that the other partner wasn't Jewish, where there's no way an Orthodox Beit Din would consider the conversion. But also there are cases where the marriage was just a green card marriage, right? So those happen too. And in those cases, you would offer the woman the choice.
Right, according to Rav Henkin, is civil marriage required to get?
Yeah. Very extreme positions are even any kind of long-term committed monogamous relationship requires a get. Whether it's the civil marriage is not the issue. Common law marriage would require a get.
But they probably have BS. So,
Yeah, well, that's the right, and where this comes up a lot, both ways, is Soviet immigrants. Right, where people, right, Jews who got married in countries where chuppah v'kiddushin were not really available, and therefore it's very hard to argue that the reason they didn't have chuppah v'kiddushin is because they were rejecting it. And it's just because they had no alternatives. This comes up a lot. So normally, in any case where a remotely sane Beit Din could take the position that a get is necessary, you write the get. But where no get Beit Din would take that, then you give the people the choice. Okay. We also have on the application the question of who will pay. The position of our Beit Din, which is not really a great financial position, is that but I think it's the right position is that we don't ever allow inability to pay to be a barrier to going through divorce, and we charge a very, very low fee, and although even that can sometimes discourage people. I don't know what this is right now. It's in the hundreds.
Yeah.
It's in the hundreds. But it's just important halachically because really, based on the pasuk, we rule that all the process has to be paid for by the husband. The document has to belong to the husband. But this is already the Gemara. The rabbi said that sometimes husbands won't be willing to divorce when they really should because of the money. So we allow the woman to pay, and we just use halachic legerdemain to transfer the money to the husband at the moment before it acquires, right, before it pays for the sofer and acquires a document. So who gives the money doesn't matter. The husband gives the money. We ask about children just because we think that it's a good idea pastorally to remind people if they have children that they're supposed to not be at war with each other in front of the children. It doesn't have any halachic implications other than mamzerut. I say the other reason I asked that question is about mamzerut. Okay, so now he also asked the question of whether they're going to appear together or not, because we assume that every part of the process, even though it says in the Torah that he gives it to her, we allow agency at every stage of the process. So the husband doesn't actually write it, and the husband doesn't actually have to give it, and it doesn't actually have to be given directly to the woman. It can go from an agent on either side. There are problems if both sides appoint agents, but it can either be the husband's agent to the wife, or the husband to the wife's agent. So we have to ask that question whether they're appearing separately or together, and that gives us the opportunity to discuss the question of what happens if one party wants this and the other party doesn't. But in that case, under almost all circumstances, our job is to get the other party to cooperate. Right? But just you have to know when you call the other party whether you're calling somebody who will say, "Oh yes, I know about this, and I'm happy to cooperate," or what? Or I'll see the other person burn for thousands of years before I agree to engage in this, or anywhere in between. Like I'm happy to do this in exchange for $30,000 and the sports car of my dreams. Right, so you have to know what you're walking into in those cases, and the things that go most wrong are. Sometimes it's good. We had a case recently where I had a call from somebody's rabbi saying, I don't know how to deal with this case. They're afraid there's no cooperation. Right? Can you deal with this? It sounds to me like it's going to be a good situation. And it turned out that it was all in the person's mind. The other person was perfectly happy to agree, as long as you called and asked politely. So sometimes it works out that way, and sometimes you think the other party's going to agree and you don't, or you don't get the information, and then bad things can happen. Okay, so far we're at the application process. Now let's suppose that both parties show up together. So what actually happens? The first thing we do is ask them their names. So how do you write their names? So if you go to the next page of the source sheet, so you'll see there's a Mishnah and then a statement by Vidam or Shmuel, that's the part translated, which addresses the question: what happens if somebody lives in multiple jurisdictions and is known by different names in those jurisdictions? Okay, probably all of you have circumstances like that. As I know, one of the students was telling me recently that they talked to an old friend of mine who said they knew me back when I was Robert. But for much of my life, I lived in two different spheres. There were the spheres where I was known as Robert, which was family and school, and the sphere where I was known as Aryeh, which was camp. And then there were the poor friends who knew me from both places who wandered around with schizophrenia. I, of course, was perfectly sane. So how do you handle circumstances like that? So the Gemara says that the people of Midyat Hayam, which I usually like translating Atlantis because I don't really know where it is, sent a question to Rabbi Gamliel, saying if there's a person who came from there to here, his name is Yosef, but they call him Yochanan, or Yochanan they call him Yosef. How do they divorce their wives? They don't know what name to write. So he wrote, right, the language of the Mishnah is, Gamliel arose and decreed that you should write each ploni v'chol shum sheyesh lo. So here we get into a tikkun ha'olam. Tikkun ha'olam here, as in most places of Rabbinic literature, doesn't mean a dramatic transformation of the universe in order to accomplish various social justice purposes. It means the legal system functions in a way that achieves the results that are intended. And Rav Ashi says it only works if both names are real. So the basic ambiguity here, as we'll see, is did Rabbi Gamliel decree that you should write so and so? Let's say we'll call the person John Doe, and every other name by which John Doe is called, meaning that you should specifically write every other name that John Doe is called. Or did he come with a clever legal device and say you should write John Doe and all his aliases? So that unfortunately becomes a big debate, which generates all sorts of halachic confusion for many years, which is why the quotation mark is something that would have greatly altered halachic history had someone thought of it. So I gave you on the next page, I believe, is actually a photograph of this is a get from the internet, but it's not really a get. You'll see that what the person did was take what probably was a valid get and Photoshop in other names. And the reason they did that, and I'm very glad of it, is that they're really very nervous we never allow a real get to be seen by anybody, because if they see it, they might find a flaw. So we always, as soon as a get has been delivered, we tear it in a way that demonstrates it's been used, so it can't be reused, and we file it, and nobody ever sees anything but a receipt. So I was really nervous. I had a book that Rabbi David, gave me a couple of weeks ago, which includes a photograph of the first get written by the Beit Din. He is the heir to in Los Angeles, which was 146 years ago. And he reproduces it, and it's beautiful, but it makes me nervous, because who knows? We can find the descendants of those people, and maybe I'll find a flaw. So I didn't want to reproduce it for you. But what these people did on the internet, sorry, I forget the site. I should have. But they photoshopped it. They photoshopped it in. So you'll see the two witnesses are Reuven, son of Yaakov, our forefather, and Moshe Rabbeinu, the son of Amram. I don't think those were the original witnesses. And he actually puts in, if you look at if you look at the line 30, it says Ana, right in the middle of the line, it says Ana, Ploni, right, John Doe, Demiskari Ploni ben Yitzchak, right, who is called Ploni, the son of Yitzchak, Demiskari Isaac, who was also known as Isaac. So it was a real case, I think, a real get, which involved the son of Yitzchak was also known as Isaac, and then they substituted the names John Doe for the first couple. But you see, what we do as Ashkenazim is we actually try to write all the names. So really, the first thing that happens on the phone, and what happens when you come to Beit Din, is we run an investigation of what your name is. And we probably don't have time to do the halachic material in depth, but it turns out that it's really, really complicated to figure out how you write someone's name. So, for example, if you look in the Shulchan Aruch, you'll see that we're supposed to write the name that people generally use and are most known by. So we have to deal with. So let's say if you're Aryeh in camp and you're Robert in school. So where are you most known? the number of times people call you. So, right, so if you happen to have a family members who just spend your time trailing you, calling your name, so they count a lot more than the other people. This is leaving aside the question of the location of where you are, how we deal with telephones. And what happens if you are here, but you're mostly, right, but you spend most of your time conversing with people over there, which happens all the time. Right, Soviet immigrants who spend, right, where do they do that? They're spending their time on the phone with their mother. Right, so even if everyone here calls you, right, calls you this, but your mother calls you that, and most of the time, right, but your mother's in Moscow and you're in Boston. So it gets, then the question that we always ask, which we have to warn people in advance is an odd question, is people usually give you their Hebrew name, right? The first question we ask is, what's your Hebrew name? So there's a presumption that your Hebrew name is your real name. So you ask people, okay, how do you know that's your name? And often people don't know. That was, if you get fascinating answers, when we were married, the rabbi thought I should have a Hebrew name. So he wrote it, right? So he gave me that, and I've used it ever since. I learned actually when I was at a meeting of the United Ministry at Harvard, and they decided to run as a session, everyone should talk about how they got their name. Now you would think that was a pretty simple thing, but I think I was the only person in the room who still used names I had been given at birth, and I had two names. Right, leaving aside the question of middle names, which we'll get to in a moment. So it really becomes a very complicated question as to how you balance the name of your Jewish name, distinguishing between Jewish names that were given to you at birth and Jewish names that were given you subsequent to birth. Figuring out whether Jewish names are names that you still use, and you run into problems because some people take the position that your primary name is always the Jewish name. It never gets wiped out. Then there are clever positions, which is you have a ketubah. So a ketubah is a live legal document, so that always, right, so you can never consider a name to be forgotten as long as it exists in the ketubah, because the ketubah is a live legal document. And you have other positions that say if nobody knows your Hebrew name, that's it. It's gone. You have the question of how you deal with signatory names. So we usually ask, what does the IRS call you? We look at passports and driver's license, because people who think their middle name is never used. Turns out often it's on your driver's license. My contribution in this is asking about email addresses. So middle names often reappear in email addresses because you become, right, you'll be, right, John number 80,636, right? But if you're John Engelbert, right, you might be number 2 or 3. So people who say, no one ever called me John Engelbert, will email you the next day, johnengelbert@yahoo.com. So those are really, really complicated questions, and those are usually the most fun that judges have, because we get to have long, learned conversations about how we should write the name or not. In the end, in our Beit Din, we almost invariably just end up writing the English name into any question, because according to almost everybody, so you can look and you see that Ramah says this. If you write one name that you're sure is the right name, if you're sure it's a right name, you're probably safe. As opposed to Sfardim, who have to write and all other name by which it is known by. And once you write all the names by which they're known, you have two problems. A, what if there are no other names they're known by? Does that imply that it's false? Secondly, is that an explicit statement that this is the primary name and all the other names are secondary? So Sfardim have a much harder time than we do. And then you have a second issue, which is if you're writing multiple names, some names are called Dimiskaria, who is also called by, and some names are called Hamachuna, which they're nicknames as opposed to names. And you have to identify properly what is a secondary name and what is a nickname. And that requires you to make judgments about, you also don't write names that are just short names of previous names. And this requires, usually in order to determine this requires me to go back into my memory of sports players from 2 decades ago. But that is often the only way we can tell whether something is a live name or not is whether I can remember a baseball card which had somebody being called this. So for example, UL obviously is a name because there was an infielder for the think for the Athletics in the late 70s under Charlie,
Royals.
early 70s. Was it Royal? I think he's on both. I think he starts with the Athletic. I think he's one of. You're right. Hey, we'll have to check this out. Was he only on the Royals? He was on the A's. Am I confusing him with the guy who was just the pinch runner?
Second baseman.
Yeah. Any case, so he just had initials. Right, good. Right, just had initials. UL. So right, so UL is maybe maybe do you count the L as a middle name? So just U is now a name, or L. So that's often how we make the decision, is whether you can remember a sports player by that name or not.
Spelling issue?
Then you have to figure out how you spell the names. Right, we're going to get to that. So how do you spell names? So you spell names the way they sound, unless they are written in Tanakh. If they're written in Tanakh, then you're supposed to write them the way they appear in Tanakh.
Hebrew?
So now the question is, what does it sound like, right? So if you're fortunate enough to have a name like Eliyahu, so you write Aleph Lamed Yud Hey Vav, because that's the way it is in Tanakh. But if it weren't the name that appeared in Tanakh, so then you write it for our Beit Din, you write it in Yiddish. So Eliyahu would be Ayin Lamed Yud Aleph Hey Vav. Right, because the ayin is an F, and the aleph is an O, so it's Eliyahu. Now, the problem is there are two things. A is that what you hear is really discovered. What you hear is really, you hear with an accent in the same way that you speak with an accent. So when people say they're, right, because you very rarely hear the sounds you can't pronounce, and you often translate it into the way you would pronounce the same name. So, and this next thing is that you try very hard not to change. So if a name has been spelled a particular way once, you try very hard to always spell the name that way. So my favorite, which we still use there are a number of lists, there are whole books. I say Rabbi Ru just published a book called Shem Mishmuel, I think, which is his teacher's list. It's his list of every name and how it was spelled of every get written in all 8,000 Gittin or something that were written in his quarter of the past 140 years. So something that's just a list of names alphabetically. And there are many, many books like that historically. Rabbi Goldschmidt of Moscow gave us a book of how to spell Russian names. My favorite two things to spell are Irving. Irving, which our Beit Din spells Aleph Vav Yud Resh Vav Vav Yud Nun Gimel. Because we spell the way Rav Henkin did, and Rav Henkin said Irving. So if you come in named Irving, we will write Irving. The other one I love is, I believe that the standard spelling, it doesn't come up for us in Boston obviously, but the standard spelling of Mississippi in a get is Mem Yud Samach Samach Yud Samach Samach Yud Pei Pei Yud. The first person who wrote Mississippi didn't use Yiddish transliteration; they used letter substitution. So, right. So those are my favorite spellings. When I was in the kollel, the Yadin kollel, which is about Gittin and civil law. So the thing to realize and tell my students, when I was really until after I got out of smicha, I found practical halacha really dull. And no interest in all the notions. And it's really partially what got me interested in it was because I was in this kollel, so I got to be part of this Beit Din and I got to see how it actually made a difference. But I joined the kollel because I wanted to write philosophy of practical halacha, and I thought I should have some data. So I thought I would learn some practical halacha so I could then write philosophy about it. But I really didn't find practical halacha interesting at all. But as part of this kollel, you had to give a lecture on practical halacha every once in a while. So my first lecture I always tell my students was on, there is a rule that again, every other contract, the witnesses have to sign on the same side of the paper as the document. They can't sign the back. So my first very, very practical legal lecture was about a get, which was written and then signed on the back, right? So again, on a Mobius strip. What's the back? Right, that was my first Klapper. My second one was on there is a rule that a get has to be written on something that is detached from the ground. So my second one was getting written on hydroponically grown lettuce. The question: are hydroponic vegetables considered to be attached or detached? And my third was Velcro kitten, or adhesive kitten, because we'll see. One of the ways in which you can give the get to the wife is by throwing it into her property, and the get is valid not at the moment it hits the ground, but at the moment after it reaches the apogee of its arc, because if it's on its way down, right? So we see it as if it's landed already. So if you throw an adhesive get at the ceiling. So the question is, right, is it valid at the moment, right, even on its way up, because it does that. And my fifth was about replacing getting the Social Security number.